We now resume with testimony in the honor killing trial of Yaser Said. The defendant is on the stand. Said is accused of shooting his teenage daughters, Amina and Sarah, because they were dating American boys. It's now up to the defense to prove that Said's claim that he was not the person who killed the girls. Said is testifying via an interpreter. His story so far in direct examination: a suspicious vehicle was tailing him back in 2008, so he left his daughters on the side of the road in the car as he drew away the danger. Is that going to uphold through cross-examination? You haven't missed any of the testimony. Let's get you back into court for continuing cross-examination.
Both sides are instructed to desist from showing any emotional outbursts, either by way of speaking or bodily movements towards each other's objections. Is that understood?
Yes, Your Honor.
Okay.
No issue from the state.
Yes, Your Honor.
Okay. State may proceed.
Thank you, Your Honor. You were indicted for molesting your girls, Sarah and Amina Said.
Objection, Your Honor. Under 608, this is impermissible. Under 404, it's impermissible. They have no right to start lodging these extraneous offenses against this client or against Yaser in the middle of this cross-examination. Just because they're cross-examining a defendant, that does not mean the rules of evidence dissipate. And it is wholly improper for them to get into these extraneous offenses that they fail to substantiate or provide any evidence of just because it's cross-examination.
What's the state's response?
Your Honor, it's wholly permissible. We've heard evidence that that was an allegation, and I asked him if he was indicted. I didn't ask him the manner and means.
608 requires conviction, not
I'm
indictment.
speaking. I didn't ask him the manner and means, and Your Honor, he can be cross and extraneous offenses.
May I respond briefly, Your Honor?
Go ahead.
Yes, if they can find an exception to the rules of evidence that are designed to allow for credible evidence and credible extraneous offenses to come in. They clearly do not understand the language of 608 or 404 and are trying to backdoor this character evidence without even meeting the requirements of those rules. 608 does not permit them to get into this, and I would object under 608, under 404, under 401, under 402, and the fact that all these allegations are based in nothing but hearsay and subsequently recanted. I would object under 801 and 802 as well, Your Honor. Furthermore, I would like to raise the Confrontation Clause issue that he does not have the ability, that we do not have the ability to cross-examine the individuals that were part of this allegation. That witness has come and gone, and it is wholly impermissible to lodge these false allegations against my client just because it's cross-examination.
All right, pursuant to 403, the court will sustain the defense's objection.
Your Honor, may we approach?
You may.
I'd like to welcome, while they're at a sidebar, my guests for this hour, criminal defense attorneys Jack Rice and Josh Schiffer. Gentlemen, I'm always glad to have you. You know that we love breaking down the legalities of these cases. And let me just say this, I thought that defense attorney was pretty angry and a little testy when he was arguing the state doesn't get to just ask anything they want and things they don't have substantiated of my client, and the court sustained it and said 403. Jack, let's start with you. What does that mean? What did the court just sustain?
Well, let's start this way. The defense attorney is a little bit testy because his client is getting destroyed on the stand, and there is nothing he can do about it. I mean, that's the first problem. You're literally sitting there on your hands, and as somebody decides whether they're going to take the stand, you continue to tell them, and I know Josh has done this too, you say, I may not be able to protect you once you take the stand. So that's a big part of this. This has to do with character evidence and whether or not it's admissible in this case. If it hasn't been put in as part of the defense, as part of what the defense is arguing, it's inappropriate at this point to make simply this introduction of the allegations. It's more prejudicial than probative, meaning essentially that it doesn't really help the jury do anything, but it sure makes him look like a horrible, horrible human being. And he seems to be doing that just fine by himself.
And, you know, they're going back to their places. So, Josh, I'm going to hold a question for you, but the court heard motions on this earlier. Let's get you back into the courtroom.
So the state will phrase its questions accordingly, appropriately.
Yes, Your Honor. You were violent to Amina and Sarah, correct?
Objection, Your Honor. Under 404, this is impermissible character evidence. There is no evidence that has been submitted. There is no physical evidence produced in this case. There is no there's no basis for these allegations other than the state's narrative. And we would argue that under 404, this is impermissible. Furthermore, if they're going to try and get into it under 404, they cannot make an umbrella objection to those exceptions. They have to specifically identify motive, intent, plan, or whatever their choice is, but they have to identify that. They have failed to do so at any point in this jury trial in their attempts to get into this stuff. And furthermore, under 403, the prejudicial effect substantially outweighs the probative value given the nature of these allegations and the lack of evidence to support them. And I would re-urge under 801 and 802, this is impermissible hearsay or based on impermissible hearsay. And so for those reasons, Your Honor, the hearsay rules, the relevancy rules, the character evidence rules, most of the rules of evidence deem this improper for them to get into at this time, regardless of the fact that it's cross-examination. Again, the act of cross-examination does not kill the rules of evidence. So for those reasons, Your Honor, we would ask that they be limited in this attempted extraneous offense fishing expedition.
What's the state's response?
Your Honor, this is extremely relevant to this case and it is permissible under Texas Code of Criminal Procedure 3836 in all prosecutions for murder. The state or the defendant shall be permitted to offer testimony as to all relevant facts and circumstances surrounding the killing and the previous relationship existing between the accused and the deceased, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense. As for 404B, Your Honor, this goes to motive, this goes to intent, this goes to absence of a mistake, this goes to opportunity, and we believe we are allowed to ask him these questions, Your Honor, as allowed within the code.
Brief response, Your Honor.
Go ahead.
As they stated in their response to this court, to admit this evidence, it has to be based in fact. They have not produced a single witness to establish any of the facts that they are alleging. If they wanted to get into this stuff, there was a way to do it. There are the proper witnesses and there's a proper procedure, and they're trying to bypass all that and create facts to fit this case law, or excuse me, the code that they're citing. Without the facts, by their own argument, they cannot get into this. They have failed to establish those facts, and it's wholly improper. And I would re-urge all those arguments that I made earlier, and most specifically under 403, that again, the probative value substantially, the prejudicial effect substantially outweighs any probative value that can be assigned to this extraneous offense fishing expedition.
Your objection's overruled,
Thank you,
counsel.
Your Honor.
State may proceed.
Thank you, Your Honor. There was violence in your home, correct?
كان في عنف في بيتك صحيح؟
أيوة أنا متجوز بقالي حوالي 30 سنة. ولا في حد من الجيران اتصل ب911 ولا في حد من عيلتي اتصل ب911. جميلي أسرة مفيش واحد مراته اتصلت بالشرطة. أنا I never have. Where does the violence come from?
Where does the violence come from? If I've been married for 30 straight years, not a single incident where a neighbor called or any one of my family called about violence. 911, called 911 about violence.
But you threatened to kill Patricia if she did not recant the charges against you in Hill County.
Your Honor, again, I'm going to object for all the same reasons as before. That is based on a hearsay statement. They have not established this as fact. They have not done the proper prove-up to get into any of this. This is all them trying to create these facts to get into these extraneous offenses. There has been nothing presented to this jury that there is any truth to any of these allegations that they're trying to get in.
Your objection's overruled, counsel.
May I ask?
Overruled. The defense continues to make these objections. We will need to take a break, but Josh, I want to ask you first, are you surprised that all these arguments, remember, are being done in the presence of the jury, and they've gone to pretty extreme measures to put everything on the record about why they're objecting?
I don't see why the judge is even entertaining this in this fashion, because from my eyes, this is creating a couple of issues, regardless of how strong they are, that are for appeal. And the state is doing such a strong job with their case. At some point, they need to accept the obligation that they should dial it back, that they need to focus on their strengths and not push boundaries. This is a straightforward case. There's no reason to create an opportunity for appeal.
And there are so many things to talk about in terms of what happened this morning to set the stage for this testimony. We have to take a break, and when we come back, you're not going to miss any of the defendant's testimony. We will get you back into the courtroom.
Tonight on Closing Arguments, it's a story that's made headlines across the country. The Alec Murdaugh murder mystery. The disgraced attorney is accused of murdering his wife and his son.
Closing Arguments tonight at 8/7 Central. 4/9 now.
I want to get you back into the courtroom in the state of Texas. In Dallas, Texas, Yaser Said is accused of shooting and killing his two teenage daughters, 17 and 18 years old, because they were dating boys who were not Muslim. Now, his defense, he's on the stand. He's telling the jury his story. Remember, the state just rested today. He is the first witness for the defense. You haven't missed any of his testimony. Right now, he's under cross-examination by the prosecution. Let's get you right back into court.
What do you mean by that?
Laws protect women. At least she could tell her family, for example.
Okay. Patricia left you several times, didn't she?
Patricia, صحيح. Yes, and I don't remember how many times.
It was a lot of times, wasn't it?
Your Honor, first I would ask for running objection to the extraneous offense thing. I don't want to take up the court's time or interfere constantly with this. I mean, I do, but you've made your ruling. And so I would ask for a running objection on the extraneous offense issues, and I would also raise the objection that this is way beyond the scope of direct examination, and that their line of questioning be directed at the direct examination specifically. If they want to contest anything that he said on direct examination, of course, cross-examination is the appropriate way to do that, but they're trying to get into the entire life of this, and again, for all the extraneous offensive issues, we believe that at the very least under 403, this is improper and should be prohibited by the court.
All right, your request for a running objection is overruled. You will object when you deem it fit, and your objection's overruled.
Thank you, Your Honor. She left you a lot, didn't she?
Not too many times, maybe maximum 2 times as far as I remember.
She always came back.
ولكنها دائما كانت تعود ترجع تاني. Meaning she was not afraid I would kill her.
She always came back because you demanded she came back, didn't you?
كانت بترجع لأنه أنت كنت تطلب منها إنها ترجع. This is not true.
Okay, let's talk about the missing persons report that you filed. December 26, 2007, do you remember calling Louisville PD about Patricia and the girls leaving you?
إذا ديسمبر 26 2007 عملت تقرير إنه مرتك وبناتك مختفيين، تتذكر ذلك؟ I would say that too. I don't remember dates.
But you remember calling the police.
Yes, I do.
And you knew they left because they were so scared of you.
وبتعرف هم سابوك علشان خايفين جدا منك.
أولا معرفش هما ليه سابوني في الوقت ده. لما جيت أنا ما كنتش أعرف القصة إيه أصلا.
When I came home, I did not know the story, and I don't know why they left to begin with.
Well, you knew they were not harmed.
ولكنك عرفت إنه ما كانوش منأذين، يعني كانوا بخير. I called the police because I wanted to know where they were.
Right, but you knew they were not harmed.
ولكنك بتعرف ما كانوش منأذين، يعني بخير.
جوزها بجد البيت ما كانش المرة والعيال عايز أعرف راحوا فين. Very simple question.
I'm a husband who came home, did not find my wife or girls. I had to ask where they were, simply.
You didn't call any hospitals.
ما تصل مني شافي.
اتصلت first بالبوليس.
First of all, I called the police.
And you asked for them to bring your girls home.
وطلبت منهم يعيدوا عائلتك إلى البيت.
كنت عايز أعرف كل الموضوع.
Definitely, I wanted to know where they were.
Because you knew they were unharmed.
لأنك عارف إنهم ما كانوش بخطر. At that time, I did not know if they fled or not fled, who they were with, or what not. So I did not know details at that time.
Going back to the night that Amina and Sarah were murdered, who picked you up from the Omni?
أمني يوم الوفاة أو الحادثة مين أخذك من الأمني؟
مين قال إن أنا كنت في الأمني؟ يعني هي جايبة القصة دي منين؟ أنا مش فاهم.
Who said I was at the Omni? I don't understand where this story came from. I wasn't at the Omni.
And you turned off your phone?
كنت طافي تليفونك. The phone was in the car.
And you had no plan?
وما كانش عندك خطة؟ مخطط؟
مخطط ليه؟
Why would I have a plan?
إيه؟
And what kind of plan?
Objection, not responsive, Your Honor.
Sustained.
I don't understand your question.
You said you had no specific plan. You hoped a friend would just pick you up and give you a ride.
ما كانش عندك خطة، كنت متأمل صديق ليك ياخدك ويوصلك إلى مكان ما. I never said that.
You just testified to that on direct. You said you had no specific plan. You hoped your friend would give you a ride home.
أنت قلت إنه ما كانش عندك خطة ولكن كانت يعني تتأمل إنه حد من صحابك يوصلك.
حد من صحابي شاف يقول لي تعرف النص وسطها يقول لي فهي بتتكلم على أنهي منطقة.
It depends which location you're talking about.
When you ran away from the cab.
لما هربت من سيارة التاكسي.
بالظبط ما كانش عندي خطة زي ما أنا قلت بالظبط ما كانش عندي خطة.
Like I said exactly, I did not have a plan. And I was for real looking for someone I know, one of my friends.
Who picked you up?
مين وداك وصلك؟ أخذك يعني. No one, I walked by feet.
Who picked you up at the Waffle House?
الوافل هاوس؟ مين أخذك من الوافل هاوس؟ I never said anyone took me or picked me up from the Waffle House.
Where did you go? You didn't go home?
أنا رحت على البيت، رحت فين؟
Your Honor, I'm going to again object and assert his Fifth Amendment right, given that this goes into the flight element of the federal prosecution. It is not relevant to The questions they're asking are after the date and time that is pertinent to this case. And because he has the pending federal issue, we would like to assert his Fifth Amendment right to not answer this question and potentially incriminate himself in that federal case.
What's the state's response?
Your Honor, this goes to his consciousness of guilt. This is relevant. I'm able to go into any area in cross-examination that's relevant to the case.
May I respond, Your Honor?
Yes.
I believe it's needlessly cumulative. They went to great lengths to show that he was found at the Justin House in 2022. What happened during that time is potentially going to expose him to additional felony prosecution, or excuse me, federal prosecution. They've established what they needed to establish in regards to that, so it would be needlessly cumulative, and also, therefore, the probative value, or excuse me, the prejudicial effect would outweigh the probative value, Your Honor.
Thank you. Your objection's overruled. State may proceed.
Thank you, Your Honor. Where did you go? You didn't go to your house.
رحتش بيتك ورحت فين؟ I'm familiar with that area. I was hanging around in that area.
Until when?
لإمتى؟ A while. I don't remember how long.
So you just stayed at the Waffle House until 2020? You just hung out at the Waffle House?
قعدت بالوافل هاوس لحد ما دخلت السنة الجديدة 2020. Waffle House was just a stop. Then I left because I was avoiding public areas.
We have to get in a short break, but we will pick up where we left off in the honor killing trial right on the other side. Plus other headlines, including sentencing in the federal hate crime trial and the death of Ahmaud Arbery. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Good afternoon to you. We're going to get you back to our trial coverage in just a moment. But first, we want to get you caught up on some other legal stories that we are following. Breaking news in the death of Ahmaud Arbery. The 3 men convicted of violating his civil rights are being sentenced today. Travis McMichael, the man who shot Arbery, was sentenced to life in prison just this morning. His father, Greg McMichael, was also given a life sentence just a short time ago. And William Roddy Bryan, who took part in the chase and recording the shooting, he will hear his sentence next, concluding today's federal hearing. The 3 men were convicted of federal hate crime charges in February following state convictions in Arbery's murder. Lawyers for the McMichaels are asking to serve out their time in federal custody instead of state prison. In Ohio, a man suspected of gunning down 4 people in 2 houses has been arrested. Stephen Marlowe was apprehended in Kansas over the weekend following a 2-day manhunt. The shootings happened on Friday, and prior to that, Marlowe ranted on social media about believing he was the victim of mind control. The victims range in age from 82 to 15 years old. Stephen Marlowe will now be extradited to Ohio to face charges. And in California, the trial of Paul and Ruben Flores continues with day 9 of testimony. Kristen Smart disappeared after leaving a college party on May 25th of 1996. Today, we heard testimony from one of the 3 people who helped get Smart back to her dorm room after she passed out on the lawn of the party. Timothy Davis testified that Paul Flores just kind of came out of the darkness and inserted himself next to Cheryl to walk Smart back to the dorms. He then said once seeing the dorm, Cheryl stated Timothy could leave, and he gave Kristen over to Paul and said he'd walk her back, but didn't ask what dorm she was in. We will have a live reporter from California next hour with more updates in the Kristen Smart murder trial. And that's it for your legal news briefs today. We want to get you back into the courtroom in Texas. Again, Yaser Said is testifying. He's on cross-examination, so the prosecution is having the opportunity to ask him questions and try to poke holes in his story. You've not missed any of his testimony. Let's get you back into the courtroom.
And then you got to the Justin house with your brother Yasin and Islam.
بعد كده رحت على البيت بتاع جاستن. انت وابنك اسلام واخوك ياسين. No, not right away.
But you ended up there. That's where you were arrested, in the Justin house.
ولكنك بعد كده رحت لجاستن هاوس واتمسكت هناك. This was after the house was abandoned and I used it.
This is where you slept, isn't that right? You see that picture there? That cot? That's where you slept?
السرير ده هو السرير اللي انت عليه صحيح؟ This was a storage room inside the garage. No.
So you slept in a bed in the house?
نمت بسرير. Does it have to be a bed? Why you're asking about the bed?
I'm asking the question. Did you sleep in a bed in the house?
نمت بسرير في البيت. Sometimes I would use the couch.
Comfortable?
مريح.
Objection, relevance.
Were you comfortable?
I didn't have a problem.
You didn't have a problem. You had food to eat, correct?
صحيح. I had food.
You had something to drink for nourishment?
ومشروب أيضا. حاجة تشربها. Definitely.
Air conditioning?
وتكييف. I was not using air conditioning.
Okay, so no air. So you were uncomfortable? You were hot?
إذا ما كنتش مرتاح كنت سخن. Not necessarily I was using.
Not necessarily?
Wasn't important to me.
Right. It's important that you remained hidden, right?
لكن أهم حاجة إن أنت كنت متخبي. I never said I wasn't hiding in the house. I used the house.
You were hiding in that house, right?
كنت متخبي في البيت ده صحيح. Not all the time.
So you went to the police? You made a statement?
رحت واعترفت الشرطة. Wait a minute, which house you're talking about?
The Justin house, where you were found and arrested.
Justin, مكان اللي وجدوك فيه. What about the Justin house? I need to know
You
what
can't understand me now? You don't understand what I'm asking you?
I want you to repeat this question.
Okay, so you're talking to me in English now. So you understand me very clearly, don't you?
I didn't say I don't know English. I know some English, of course.
Yeah, Your Honor, I want to object to her badgering the witness. He was ordered by this court to speak in his native tongue. English is his second language, which is why we have a translator, and it's not fair for her to sit here and beat him up for doing exactly what the court has ordered him to do.
Sustained.
I'll move along, y'all. You knew you were on the FBI 10 most wanted list, didn't you?
كنت أعلم أنه بدي على قائمة القائمة الفيزيائية من ضمن 10 أشخاص المطلوبين صحيح؟ Of course.
Did you watch the news?
إذا كنت تشوف الأخبار؟ Sometimes.
You had a TV.
I'm not a big TV watcher, so sometimes.
And you said the coverage was too harsh.
وقلت ذكرت قبل كده التغطية الإعلامية كانت شديدة.
أنا بقول شوفي كل تاريخ أمريكا في قضية عنف أسري اتردد بهذه الطريقة. كل تاريخ أمريكا.
I don't think in the entire history of America there is a case that has the coverage that my case had.
Too harsh, right?
شديدة جدا.
كان فيها عنصرية شديدة و double standard.
There was prejudice and there was double standard to it.
If you didn't kill your daughters, why did you hide for 12 years?
إذا أنا قتلت بناتك اتخبيت لمدة 12 سنة ليه؟
لأن التغطية السيئة كان طبيعي إن مش هيكون في فرتراكي بسبب التغطية. هذه التغطية كان وراءها أجندة أخرى خفية.
Because I believe behind this coverage there was a secret agenda, and then all the media was steered in a certain direction and fueled against me that I will not get a fair trial. Interpreter would like a clarification?
كانت في أجندة لتحقيق هدف سياسي overseas.
The agenda that I was talking about, maybe the agenda that was maybe put into for certain sides in the Middle East, but that's why I escaped, because I was afraid I'm not going to get a fair trial.
Still with us, criminal defense attorneys Jack Rice and Josh Schiffer. Gentlemen, I want to tell you something that happened this morning to put into context how you think this cross-examination is going. There was a motion, and long story short, here's how it all shook out. This defendant will testify, they said today, as to what happened on January 1st, and the judge ruled that that would include anything about fleeing and eluding the police. But that was it. On anything else, he was claiming the fifth, meaning he was his right against self-incrimination. He wasn't going to testify about anything other than January 1st and fleeing and eluding the police. Josh, let me start with you. What do you think of his testimony?
Yeah, well, you can't just put a toe into the Fifth Amendment. You really jump in or you stay out of the pool. This testimony, from my perspective, has been a disaster for his defense. I don't think that I've really heard much exculpatory evidence. And like we talked about last week, he does have a defense if he wants to reframe this case and put his case in a larger case involving mistreatment in the media of all Muslims, or basically putting our criminal justice system on trial. But that includes a lot more than just standing up as the witness and saying, this wasn't going to be fair. Julie earlier today had just been so frustrated watching this and noted that it sounds almost like an excuse, not a defense. And that's really where I'm landing on the testimony right now. I don't even know if somebody like Jack could rescue a direct and cross like this.
And Jack, I have to say, I think Josh may have the quote for the day that you can't dip your toe into the Fifth Amendment, because I too thought, well, this is interesting. He's going to testify about this only and claims the Fifth for everything else, but that's where we are. What are your thoughts, Jack?
Yeah, I said this on Twitter. He's killing it. He's absolutely right. You can't do this. Although I think if I were the prosecution, I might clean this up a little bit by saying something like, so you ran from the cab. You didn't check on your girls. You left the gun. You didn't check on your girls. You went to the Waffle House. You didn't check on your girls. You went to the building, to the house. You didn't check on your girls. You slept on the couch. This went on for year and year. You never checked on the girls. You continue with this because the whole point is no father who's claiming that this didn't happen wouldn't have at least done something. And this is a drum that you beat over and over and over again because you want the jury to go home humming that in their head like a song that you can't get out of there.
Classic trial skills, Jack. That's exactly how you should be asking cross-examination questions when you do cross-examination. All right, we do, gentlemen, have to squeeze in a break, but you're not going to miss anything. We're going to hit the pause button. So when we come back, we're going to get you back into the courtroom for continuing cross-examination of Mr. Said, the defendant in this case.
What's going on, man?
The double murder trial of Yaser Said.
The father is accused of murdering his 2 teenage daughters.
Allegedly because he didn't like the boys that they were dating because they weren't Egyptian.
The defendant spent 12 years on the run.
His flight from justice ended, and justice for Amina and Sarah begins.
The honor-killing trial. Texas versus Said. Live coverage today on Court TV.
4242.
Yaser Said is on the stand under cross-examination by the state, poking holes in his story. Let's get you back into the courtroom. You have not missed any of his testimony.
Yes. I'll pass the witness, Your Honor.
Thank you, defense.
Thank you, Your Honor. Ma'am, proceed. Yaser, you don't deny that you wish that you had stayed with the girls that night. Is that right?
ما بتنكرش كنت بتتمنى بقيت مع بناتك بهداك اليوم الليلة.
بالتأكيد.
Certainly.
And you would do anything to go back and change what happened to them that night if you had the ability to do so.
وبتتمنى يرجع فيك الزمان وما بتعمل نفس اللي عملته وما بتبقى معاهم بهداك اليوم.
شيء مفروض بالتأكيد.
Definitely yes.
Yaser, did you love Amina and Sarah?
Did you?
Love Amina and Sarah.
هل حبيت أمينة وسارة؟
Look to history, look to the hundred of tales. أنا عندي مكتبة من الأفلام كلها بتشوف this is happy family.
Look at the movies, look at the tapes. I have hundreds of tapes showing how much I loved my daughters. No one has that kind of videos with their kids.
No one did this to his family.
No one does what I did to his family.
Yaser, you don't know what happened to those girls after you left that cab, do you?
No.
You know they were murdered, but you don't know who did this.
لو الFBI عملت شغلها هيعرفوا لكن كانوا بيدوروا على ياسر سعيد.
If the FBI did their work, they would have known. But they were looking for Yaser Said, and they did not do what they have to do.
قانون في أمريكا بيقول person is innocent until proven guilty.
The United States laws say the person is innocent till he proves guilty. I was not proven guilty.
In my case, Mr. Said was guilty even if he proved innocent.
But Mr. Said is guilty even if he proves innocent.
And Yaser, I know that this is...
That's my case here.
I know that this is emotional, and I know that this is difficult. But I need you to answer this question clearly for the jury. Did you kill your daughters that night?
No, sir, I didn't. He says, of course, they did.
Definitely not. I did not kill my daughters.
Thank you. No further questions, Your Honor.
Anything else for the state? Further questions?
No further questions, Your Honor.
All right. Ladies and gentlemen, we're going to take a 15-minute break, and we'll resume at 2:10.
All rise.
Ms. Interpreter, would you state?
Let me just reiterate exactly what just happened. The defense rested. That's it. That's all they're going to present. That testimony that you just heard by the defendant. That's it. That's their entire case. So defense rested. And they are recessed for the day. Still with me, I have my attorneys and friends, Jack Rice, Josh Schiffer. All right, colleagues, call you my work husbands because we got to break this down. That's it. That's all they're presenting, Josh. Are you surprised that that's the entire defense case?
So there's a value to short, sweet, and to the point, but wow, that takes the cake kind of with short, sweet, and to the point. I didn't hear much exculpatory evidence or testimony other than what I just characterized on Twitter as a pretty flat denial that he committed these murders, but there was no depth, there was no emotion. We all have children, and any parent out there being so lacking the emotion, that is so telling to me. Like it's a gut feeling, and I don't think that decision to testify really helped him. I think he either needed to go much more whole hog and put the whole system on trial, or he needed to, just sit down, shut up, and work on a burden defense.
All right, but Jack, let me push back and play devil's advocate because he did give a story. His story was he was driving them in the cab, someone was following them, he went to a place that he thought there'd be security, that he knew people, he thought the people in the car knew his daughters, that they were gonna kill him and not them, so he fled. That's why he didn't take his gun, because he thought that the people in the car behind him were gonna kill him, not the daughters, and he took off. Enough for reasonable doubt or not at all, Jack?
No, I don't think it is. Again, the problem, let's assume we're going to go down that path. Let's accept his basic premise. The problem is there's a whole series of things that I think any normal person would have done subsequent to that. He did none of those things. The idea of what this would mean, and Josh just said it again, this idea of what it would be to lose a child, to lose two children, and what that would do to you. We did not see that. His behavior after he fled, thinking he could pull them away. What's my next step? I need to make sure my daughters are safe. How do I do that? And so you're gonna look at that issue. But what's really interesting is one of the things, one of our viewers reached out to me while we were doing this, and they asked, how could the defense attorney possibly put this guy on? And the thing is we don't have the ability to stop them. Anybody who wants to testify in their own defense has a right. The judge can't stop them, the prosecutor can't stop them, and we as their attorneys can't stop them either. So sometimes all we can do is sit back, take a deep breath, watch it and go, oh my God.
I agree with you, but on the other hand, his defense did a pretty good job, because you know what they in effect did? They limited the testimony. They limited what the prosecution could ask him about, because they did say he's going to claim the fifth on anything other than January 1st, and then it went from there, and the judge said, well, he can also testify about fleeing and eluding the police. But gentlemen, they put on those guardrails, so to speak, on his testimony. All right, coming up, we're going to get a live report from Texas on the honor killing trial. Did the jury seem to find the defendant's testimony as hard to believe as we did? That's next.